pretty full room, I see. So let's go ahead on and get started and get welcome into the room, into the space. Again, I hope everyone is doing well, feeling great and rested after an extended holiday weekend. So good to see all of the beautiful smiling faces. And we just want to welcome you today, this afternoon, to our law Pillar Live Expert Session. We have a phenomenal guest speaker joining us here today, Dennis Parker with the National Center for Law and, is it economics? Did I get that right?
Economic justice, right?
Economic justice, thank you. And he is a friend and partner of the organization. He has written and published one of our TRHT briefs focused on the law pillar, one of the resources that we reviewed together as a group in some of our earlier sessions together. And so we thought it would only be right to invite Dennis here with us today to share and to lead a discussion and engage with all of our phenomenal leaders on today. Before I'll provide a little bit more context on what Dennis has planned to share with us on today. I am going to yield the floor to Dr. Christopher to share any welcoming remarks, and then we'll go from there.
Thank you so much, Ina, and welcome everyone. And thank you to the NCLEJ team. And also thank you so much, Dennis Parker, for partnering with us in producing the comprehensive brief that you did, but also for your entire career and lifetime of service in this area of law and economic justice. You have so much wisdom to share with us, wisdom born of battles won, and I imagine some lost, but it's rare that we get an opportunity to hear from someone that brings the depth of understanding and perspective that you do. So again, we feel blessed to have this time with you. We have, with your permission, we are recording the session and we'll make it available to our broader community of advocates and leaders for health equity. So Ina, thank you, and I'm going to turn it back over to you.
Thank you so much, Dr. Christopher. So just to set the stage just a little bit here, the law has been an important pillar in affecting social change throughout the history of the United States. Its effectiveness and use have changed over the country's history, as many of us know and continue to experience. So in today's discussion, we'll consider the history of litigation as a means of changing the social and economic environment, with an emphasis on both its advantages as well as some of its shortcomings. Today's discussion will also raise the numerous ways it interacts with public advocacy and community organizing and litigation efforts. And finally, Dennis will lead us in a discussion on how to consider sort of these particular challenges that we're facing in light of the recent election, and how we can continue to move forward together collectively in this space as we're thinking about solutions and next steps. So I'm actually going to hand it over to Christina, and she's going to share a little bit more about Dennis Parker and his background, and then we'll turn the floor over to Dennis to get us going in a very engaging and exciting conversation to come.
Great, thank you, Ina. Dennis Parker is the Executive Director of the National Center for Law and Economic Justice, or NCLEJ. NCLEJ seeks to assure access to government benefits programs, housing, healthcare, nutrition, and employment, and to challenge discrimination based on race, disability, gender, and immigrant status. Previously, Dennis served as the director of the Racial Justice Program of the ACLU, as the chief of the Civil Rights Bureau in the Office of the New York Attorney General, and before that, worked on and directed the educational work of the NAACP Legal Defense and Educational Fund. Dennis began his legal career as a staff attorney in the Criminal Defense Division of the New York Legal Aid Society. He has co-authored or contributed chapters to books and articles dealing with civil rights and has lectured extensively across the country. He is an adjunct professor at Teachers College of Columbia University and New York University Law School. Dennis is a graduate of the Harvard Law School and Middlebury College. With that, Dennis, you have the floor.
Thank you so much. And let me start by just saying what an incredible honor it is for me to have a chance to speak with you, and how important it is, I think, for these kinds of conversations to take place. I've taken a look at the group of folks in this cohort, and it's an impressive group. And I'm particularly impressed by the various responsibilities that you have and the various ways that you work to do the things that are so important to me and to so many other people. And so I think it's important that we have a conversation or a chance to have a conversation to speak about the way that we can forward all of our mutual goals. And I do want to emphasize that I'm hopeful that after my presentation that we can continue to have a discussion and have questions and on both sides and talk about what the path going forward is. As you heard, I've worked at a number of jobs, and the one common thing is that all of the work over the past 45 years that I've done has been dedicated in one way or another in fighting for racial and economic justice. And it's been interesting. My view of that work has changed somewhat over time since my graduation from law school in 1980. I think when I first started out, based on my studies and the opportunities that I had to work with a lot of really impressive legal minds, I was convinced that I'd be able to change the world with my newly found legal skills. And my expectations have not quite lived up to that. I do have questions about my capacity to bring about massive change, but I still believe that the law is an important part of any toolkit which aims to better circumstances for people, and particularly for people who have been deprived of opportunities and who have been treated as inferiors for long periods of time, who have been disenfranchised and have not been able to fully participate in society. And I say that it's an important part of the toolkit because I believe that law and litigation is really just one tool of many that we have to use together in order to bring about that change. As was mentioned, I am also a law professor as well as teaching education law to graduate students at Teachers College. And one of the things that I make a part of my course is a really interesting article written by a professor who is the professor of law and director of the law clinic at the Poverty Law Center at Loyola University. And it's a gentleman by the name of William Quigley. And Professor Quigley wrote a piece that is styled as a letter to a young student who is looking to pursue a career in social justice law. And I assign this letter because I think it really sums up something about law in the United States and its role. But I also assign it because I find it useful for myself to have this yearly reminder of both the challenges that we face when we try to deal with law as a tool of social change, but also the extraordinary opportunities and the benefits that can be attained if we use litigation and the law wisely. Professor Quigley talks about the difference between law and justice. And you may have heard a distinction which has sometimes been summarized by saying that as a reminder that the people who sheltered Anne Frank and her family were acting illegally, but they were acting in a way that is consistent with the idea of justice. And this separation between what is justice and what is the law, unfortunately, has a lot of examples. And they're sometimes very sharp, distinctive ones. Fugitive slave laws, systems of apartheid, so many areas where the law requires one thing, but justice requires something else. And Professor Quigley says, when speaking about this question of law and justice and what we as lawyers are taught, and the way that we're educated and the way that it operates in our society, Professor Quigley says, it pains me to say it, but justice is a countercultural value in our legal profession. And explaining his position, he states that justice work is not the essence of the legal profession. And that justice work is not the essence of, because money is in fact often the overwhelming essence of a majority of the legal work. And much of that work consists of facilitating the transfer of money or resources from one group to another. And a shamefully large part of our profession, in fact, consists of the opposite of justice, actually taking from the poor and giving to the rich, or justifying some injustice like torture or use of tobacco or mass relocation of people, or of commercial exploitation of the weak by the strong. And Quigley also reminds us that all laws are made by those with power. The powerless, by definition, are not involved in the lobbying, drafting, deliberating, and compromising that are essential parts of all legislation. Our laws, by and large, are what those with power think you should apply to those without power. And it is perhaps an overly cynical view, and it is one that is, of course, changing as the composition of legislatures change and as people who were formerly excluded get in positions where they have some measure of power. But it's still overall, I think, not an inaccurate way of looking at the way that the law operates. And even as I say what, quote, Professor Quigley, that view of the law seems like a grim one. And I can imagine you might wonder, as do my students sometimes, why it is I chose to become a lawyer, and then, having done so, why I remain in the field. I'll save part of the answer till the end of my presentation, but again, quoting Professor Quigley, is that despite the obstacles and barriers that law presents, it has also been the means by which truly extraordinary gains have been made. Now, those gains have not been enough. This is me speaking now, not quoting. They have not been, as we'll discuss later, permanent gains. And there are still far too many practices that are unjust in the country. But there has been progress. And some of that progress has been made in part by relying on the law. But what I wanted to do is to go back as the pillar that I wrote about does, but not go into that detail since you have had a chance to read it before, to talk a little bit about the history of the use of law as a way of achieving social justice. And I do that because I think history is extremely important in understanding where we are now, and in realizing that where we are now is as frightening, honestly, as it is not the first time we've been here. There have been other occasions, and they seemed really bleak. And I don't mean to underestimate at all the extent of the challenges we'll be facing, the extent of the injustices we'll be facing. But but it's important to understand how this happens, and possibly how we can take steps to address it. And so I start the discussion with the Dred Scott case, and it's a case with which you're all familiar, I am sure. But as you remember, Dred Scott was an enslaved man whose enslaver moved from a slave state into a free state. And that gave rise to a lawsuit brought by Mr. Scott saying that since I've been moved to a free state, it is illegal to hold me in bondage any longer. And it's important to realize that although Dred Scott's case is the most famous, his was not the first case. And in fact, a number of people had brought successful cases to end their enslavement. But the time that Dred Scott brought the case was a difficult time. It was the time leading up to the Civil War, a time when there were questions about whether states would be admitted to the United States as free states or ones in which slavery were permitted, whether questions about whether states could go into free states to capture fugitive slaves. All of these things were really roiling in the background when he brought his case. And it's a case that I like to have my students read because to me it is essential that there's an understanding of the historical roots of much of our Constitution and our Declaration of Independence, particularly now when there are forces that are urging historical readings of the constitutions that are locked into where we were in the 18th or the 19th century. And what the court does at great length is to talk about all of the different classes of people in the United States. And they talk about them in a way that is meant to justify their ultimate conclusion, which is that Dred Scott had no rights that white people were required to observe. And the court went even further than that and said that not only Dred Scott, but also any Black person who happened to be freed had no fundamental rights under the Constitution. And the justification for that is a very detailed hierarchy, which is set out of different classes of people, including indigenous people. And the conclusion is essentially these people, freed or enslaved, are on a lower level of the hierarchy and are not really people. And so there is no obligation of anyone to give them rights. And central was this to the idea that citizenship would not be something that is appropriate, national citizenship, to these people. And so Dred Scott remained enslaved after the Supreme Court made the decision. And the case pushed us closer and closer to the Civil War. One of the important parts of the cases, and maybe one of the themes that we'll see in a lot of the cases we talk about, is the court went further than it had to and struck down some of the federal restrictions on slavery in newly acquired territories, and laid the groundwork for the Fugitive Slave Act. And that is one of the things that pushed us into the Civil War. Dred Scott ultimately was freed by the person who had enslaved, or by the person who had bought him later, but enjoyed very little freedom in his lifetime. But one of the important things about the case is it set up some of the more positive things that happened later in the 19th century. Excuse me. As you know, the 13th Amendment was passed to end slavery as a result of the Civil War. And I should point out, because much of the work that my organization does is looking at the the fact that even that end of slavery that's included in the 13th Amendment exempts certain people, and those are people who are prisoners. And so, in effect, slavery in the form of imprisonment is still consistent with the Constitution, and that we think is an important issue, particularly for Black and Brown people. But it turned out that the 13th Amendment by itself wasn't enough to address what had to happen in order for the country to move forward in a more fair way. And what had to happen was that the hurt and the harm that had been imposed by the 13th Amendment had to be addressed. And for that reason, the 14th Amendment, which promised due process and equal protection under the law, was passed. And again, it's important to understand both what was going on at the time and the way that has changed in the 160 years since the 14th was passed. And one of the positive things, although it is something that I predict will be under attack, is something had to be done in the 1860s about Black people. What are they? They are not citizens because the highest court had held that they could not be citizens. So the 13th Amendment freed them, but it didn't guarantee their citizenship. So one of the things that the 14th Amendment did that addressed the harm that was done by Plessy versus Ferguson, that said that if you were born in this country, or if you were a person who had been freed, you were guaranteed citizenship. Again, you have to put a pin in that, because one of the issues that is boiling around now is whether or not there should be an end to birthright citizenship. And as we can discuss later, there is no question that effort to remove that part of the 14th Amendment is related to race and ethnicity in a way that is threatening. But the other thing about the 14th Amendment that was significant is that it was designed to put Black people in the position they would be had they not been discriminated against, had they not been enslaved at some point. And that's significant because although that was the purpose that the amendment was passed, the interpretation of it since the 19th century has changed. And you will hear, and we'll be talking more about the idea that the Constitution requires not fairness, not being placed in a position of non-discrimination, but just requires color blindness. And again, that is going to be an extremely significant factor in the years going forward. But I digress. The other important thing that both Dred Scott and the 14th and 15th and 13th Amendments displayed is that in spite of the incredible progress that occurred after the Civil War, as you know, there were more Black legislators both in the states and in the federal legislature in Congress than there had been at any time in our history up to now. That changed. And despite the advances that were made, and if you've seen any of there's a very compelling documentary about the Wilmington, North Carolina massacre of Black people and driving people out of town. And the same is true of Tulsa and a number of other towns where there was a movement back, where all of the rights that had been achieved for a short period after the Civil War were quickly grabbed back. And so that the opportunities that Black people had by the end of the 19th century were really greatly diminished. And what took its place was the system of Jim Crow, laws that were designed to exclude Black people. And if that time seems really far back to you, one of my memories, I grew up in a town called Mount Vernon, New York, which is right outside of the city, and there were two women still living, and there was a play called Having My Say about these two women, who in the course of their book and the play that came out of it said that they remembered when the park that they had gone to as very young children suddenly had signs that said that they could not use the water fountains in that park. So that within the lifetime of someone who was in my lifetime, Jim Crow was enacted and enforced. And it became enforced in all aspects of American society. And that brings us to another important case in terms of the history of law and litigation as a potential way of addressing issues of social justice, and that is the Plessy versus Ferguson case. Plessy versus Ferguson is important for a number of reasons. One is because it was a challenge to a discriminatory law, a law that required that Black and white streetcar customers ride in different cars in New Orleans, Louisiana. So it was important because it dealt with the Jim Crow actions that were going into effect. But it was also important because it represented a somewhat different use of law and litigation. Plessy versus Ferguson was actually one of the first test cases that were brought, and this is something that is often not covered in history courses. People understand that Homer Plessy, the man who was the named plaintiff, was arrested because he was riding in the white car in New Orleans. What they may not realize is that he deliberately was in the white car in order to be arrested. And the effort to bring that about in order to challenge the constitutionality of the separation happened because a group of Black business owners in New Orleans wanted to attack the constitutionality of these restrictions. And so they went to the trouble of finding someone, and Homer Plessy was the person who they found, who was, it turned out, significantly so light-skinned that basically they had to arrange for him to be arrested, and actually hired a detective to arrest Homer Plessy and bring him to the police station in order to challenge the law. And so again, this was not something that just came up in the regular course of enforcement. It was something that was planned as a way of highlighting the way that this law was unconstitutional. Unfortunately, as you know, the case was not successful. That the Supreme Court held, not in a unanimous decision, but in an overwhelming majority, that the idea of separate but equal was constitutional. And the argument that was made was one that to anyone at the time would have been seen as disingenuous, but was that the purpose of this was not in any way to stigmatize Black people, because it imposed the same requirement on both Black and white streetcar riders, and that therefore, and the court holds basically that Black people are being overly sensitive in objecting to this law. And that loss created the legal doctrine that would remain in effect until 1955, the idea of separate but equal. What happened almost immediately after Plessy versus Ferguson is that, although that dealt specifically with transportation, that the system of racial discrimination, of apartheid, that was put into place in the beginning of the 20th century, in the late 19th and 20th century. Excuse me just one second. I need to get some water. Excuse me. Was put into place not only in the case of streetcars, but in oh, I didn't know that. Oh, I'd love to go back and see that. But excuse me. So that spread not only to streetcars, but to education, notably to public accommodations, to employment, to housing, to virtually every aspect of American life. And we'll come back to what role law took in trying to counter that retrenchment that was the separate but equal policy. But I think the other important thing for our discussion today is that it led to social movements that went beyond just litigation to address the questions of systematic discrimination in the United States. And social movements around a number of things were going on. I mean, one of the important lessons that I think lawyers had to learn, and I'll speak more about this later, but it's part of my young delusion about how much power as an attorney that I had, is that although many of these advances are described as legal victories or legal losses, they are actually part of broader movements that are occurring. And that if you think of any major change in social justice, whether it has to do with school segregation or marriage equality or access, to disability rights, although those are often understood as being the result of court cases and legislation, that there were years of work that preceded those court cases, that legislation. And that was done largely by people on the ground in communities, in these organizations that came into existence at the end of the 19th century. And that would include organizations that dealt with women's suffrage, that worked on workers' rights, including the American Federation of Labor. The ACLU was started at that time, the NAACP, of course, and the League of Women Voters. And this led to the creation of collaborative efforts between organizations and other groups, without which things couldn't have changed. But it also led to strategies which aimed at changing broader discriminatory practices. And the one that has really been discussed the most, sometimes controversially, is what occurred after Plessy versus Ferguson, in terms of race discrimination in an effort to end apartheid in the United States. That case was instrumental in the foundation of the NAACP. And the NAACP was founded for a number of reasons. One of them was that it was an attempt to end the whole-scale lynching of a large number of Black people, and the failure of the justice system to address in any way the murders of Black people. But it spread to consider other things. And one of those was the idea of the separate but equal decision, which was the foundation for all of the different forms of discrimination. And there was a lawyer who had worked for the NAACP, a man named Charles Hamilton Houston, who was an extraordinary and underpublicized important figure in the history of civil rights in the United States. He became counsel for the NAACP. He also later became the dean of the Howard Law School, where he was a professor for a whole generation of civil rights leaders, including Thurgood Marshall. And one of the things that Charles Hamilton Houston did was to do a survey of Southern schools, of the Black Southern schools, in the early 1920s. And this was important because although the language of separate but equal suggested that everything was okay because everyone would have the same opportunity, in fact, what happened was that separate was always unequal. And what Houston's work showed was that Black schools suffered from really massive inequalities. Everything from the actual grades that were included in the schools, to the pay of the students, the class sizes, the courses offered, the length of the school year, whether or not transportation was provided, and ironically, some of the early cases challenging discrimination were because white students were bused and Black students weren't. Just the range of these issues, and made a film which is also available, or there's a documentary about his work called The Road to Brown, that shows the images that he took with a film camera in the early 20s. And so it was decided strategically that a way to attack separate but equal was to go after an area where there would be more likely success. And this is an important thing. As a lawyer, as a litigator, you're always thinking of how do I best achieve the results that I want. And one of them is a careful choice of the cases that you bring. And so it was felt that because education involved children, because there was perhaps some belief that there was I'm sorry, I just saw that note. Or am I not being heard, or?
Oh, I think that's an automated message from an AI note taker.
Okay. Have serious questions about AI too, but that's for another day, I think. But there was this feeling that maybe some sense of fairness might make people more sympathetic to the idea of challenging segregation in schools. And so what Houston and his colleagues at the NAACP did was create a decades-long strategy for dealing with, for trying to undercut the idea of separate but equal. And so that involved originally bringing cases about disparities in teacher salary and transportation and then other things, and then ultimately switched to trying to find a way to strike down, to not just look for equality, but to end the separate but equal requirement. And they did that by focusing on higher education, and in a number of southern states, as you may be aware, not only did they have separate schools, but in some cases, they completely lacked any graduate schools that were open to Black people. And so what would happen is if you wanted to go to graduate school, you would have to go to another state, sometimes with state support. In those cases, they challenged those laws, which resulted in requirements that the state either open up a Black graduate school or admit students to the white schools. And in some cases, that resulted in Black students being admitted to those white graduate schools. Those cases are among some of the saddest cases, because the students for all of the time of their graduate work were completely isolated. And there's a famous picture of Heman Sweat, who was in the Sweat versus Painter case, who was in a classroom where there is a physical barrier built around him, and the knowledge that in his years of graduate study, no other student spoke with him or no professor had any interaction with him. And that was the experience of a number of people. The next step after that was to go after where there were massive differences between the educational opportunities in the graduate schools. And a case was brought in Texas, challenging the fact that the Black law school, called Southern Law School, and now, ironically perhaps, given its history, Thurgood Marshall Law School, was at the time vastly inferior to the University of Texas Law School in terms of the size of its library, the number of teachers, the courses taught. But significantly, the court said that there was also lost opportunity, that part of the benefit of law school was getting to work with or to study with people who would later become leaders in the state, and that because of that deprivation, people were losing the opportunity to get into the legal structure of Texas. And that resulted in the court deciding that Black students had to be admitted to these schools. This is a sort of another brick that's taken out of the wall of the separate but equal, and it was decided at the time of this case that could then lead to the Brown case, which was the first time that there was a direct attack on not the question only of equality. In fact, as a strategic matter, the lawyers stipulated that the Black and white schools in the 5 places where the challenges were brought were equal, so that question would not be before the court. And they decided to just go after the question of the stigmatizing that the separation required. And that became the basis of the decision, the Brown 1 decision, which said that that separate but equal profoundly damaged children, Black children, because it was stigmatizing to them. And I think one of the significant things is that the language of the court said that it stigmatizes them in a way that is unlikely ever to be undone. And that illustrates another issue of one of the challenges of litigation, because having recognized damage to a child that is so significant that it is unlikely to be undone, the court then proceeded to not decide what to do about it, and to require that the parties come back for the Brown 2 decision the following year. And in that decision, they came up with the idea of requiring that the states proceed with all deliberate speed to address the question of discrimination and segregation in schools. And first, I think that's noteworthy because I can think of no other kind of case where the court has said, we are destroying children's lives, we are hurting those children, but we'll give you time to come up with a way to address it. There was an immediate sort of subordination of the importance of the decision with that language. And the other thing that happened is it took more than a decade for the court finally to step up and to take decisive action to end segregation. Now, we can have a discussion about whether or not the identification of segregation as the priority for education litigation was the right choice. But, you know, the bottom line is that it took decades for that to happen. And then when it did happen after a relatively short period of time, the court agreed to the dismissal of these cases. So again, this is part of the issue of how hard it is to bring about change, even when you bring a case that is successful. And I would comment, as an executive director, a lot of my work is basically trying to raise money, and so I am not as directly involved in litigation to any great extent. The one exception is I am working on a school desegregation case in Hartford, Connecticut, that was filed in 1989 and is still ongoing. The original plaintiff is now a grandfather, and he was 9 or 10 when the case was brought. And so that shows of the difficulty of when litigation by itself is the way of bringing about change. And so there are a number of areas, and we'll talk about those, and that are mentioned in the document that talk about areas where substantial changes were made. You know, one of the things that I noticed when I walk down the street in New York City is how rare it is to see anyone smoking a cigarette. And if you've watched movies, you know that you know, seen movies from the 40s or 50s, that people smoked nonstop before. And a lot of this was the result of litigation, the result of tobacco companies finally being held liable for their knowing sale of a product that they knew was deadly, and that they lied about the healthiness of it. And those things, that litigation created a change. The litigation dealing with narcotic sales brought about change and brought about penalties for the pharmaceutical companies. But as always, there are concerns about whether or not, even having won the case, that there are effective steps being made to remedy the violations. There are a whole list of important areas that there have been major changes: employment and housing and education, the creation of laws protecting the rights of people with disabilities. It is extraordinary to me how recent many of the disability laws are. They are, you know, well within my lifetime, and certainly when I was a student in elementary school, in many places no education whatsoever was provided for students with serious disabilities. a combination of litigation and organizing brought about changes for those laws. But the other common thread that's associated with that litigation is the need to monitor what happens. In the opioid litigation, the question became what happens to the huge amounts of money that were provided to municipalities and states, and a fear that in some cases they were not being used to address the problem of opioid addiction, but were used to buy more police cars or something that was not related to the goals of the litigation. And so all of these things are things that really have to be kept in mind. And I wanted to talk a little bit about, I said that there was a change in my practice since when I first started. And one of the very positive changes that has occurred is a growing reliance on the idea of movement lawyering, which is where lawyers work directly with, in ideally an equal relationship with community organizers, with community groups, with the people who are directly affected by the litigation that's going on, and that represents a change. One of my law school professors was Derek Bell, who wrote a very significant piece about the role of lawyers in bringing about social change, called Serving Two Masters. And one of the things that Professor Bell addressed was the idea that too often decisions about what litigation would be brought and what remedy should be pursued were not being decided by the clients who were most affected, but by the organizational goals of the organization that brought the cases. And he spoke from his experience at the organization I worked with for 15 years, the NAACP Legal Defense Fund, where he questioned the decision to make the focus of the cases desegregation rather than other equity cases, or equity decisions. And those are things that I think that certainly I know in my organization, we spend a lot of time talking about making sure that we recognize who we represent and that those people are fully part of the discussions about how the litigation will proceed, what the goals of the litigation are. And this discussion is an important one, and it is one that, as I said, represents somewhat of a change where the decision-making happens not in New York at a law firm or an organization, but on the ground of the people who were affected. Let me, I feel like I've been talking for a long time, so let me try to get close to finishing up so that we can have a discussion about any of these things or any questions that you may have. The significance of movement lawyering is it recognizes that, for example, as important as Brown versus Board of Education was, it was not solely responsible for all of the civil rights advances that happened in the 50s and 60s. And that actually behind that was all of the organization work that was done, the bus boycotts, the demonstrations, all of those things that happened were integral parts of the success. And the question becomes, how do you work together to make sure that you're maximizing the results of that? And one of the ways is by thinking of what you can achieve by litigation. And one is that it can be a way of applying pressure. When you sue a state, when you sue a company, that applies pressure to them to make changes, even if only because they're afraid of 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 being liable for large expenses. And that pressure can be used in a really positive way. One of the things that surprised me is in more than one school case that I had in Georgia or in Alabama, the superintendent of schools would pull me aside and say, I want to do what you are telling us we have to do. If I do that, I will be fired by my school board. So I appreciate the fact that you are forcing it. Now, that's not maybe the most common thing that can happen, but it's an illustration of the way pressure could work. We have been doing a case in Kentucky where the University of Kentucky, in order to satisfy medical debt, was seizing people's tax refunds and other public benefits without due process, without any clear notification. And shortly after we filed the lawsuit, the state changed its practices because it became clear that what they were doing is illegal. Litigation can become a way of organizing. You can organize around litigation. And in fact, the most effective litigation is where it is closely coordinated, so that you can use the filing of a lawsuit as a way of having a community meeting. You could use it for education. This is an issue that the community should be concerned about. Look at the facts as they are laid out in this lawsuit, and you realize how much we are being damaged. So that there are ways that litigation can be really, really positive. And I wanted to briefly talk about, although I welcome conversations later, about some of the current challenges that we're facing. And the biggest one is the growing conservatism of the courts in many ways. One of the things that you're taught about in law school is the concept of stare decisis, which means that basically courts should not casually overrule earlier decisions, because it makes the possibility of political decision making greater. It makes it hard for people to know what the current law is, and it undermines support for the legal system. That has largely been abandoned. If you look at some of the significant cases, and the two that come immediately to mind are dealing with reproductive freedom and with affirmative action. In both cases, the Supreme Court had recently upheld both the right to abortion and the use of race in admissions for higher education institutions. In spite of those recent cases, the current Supreme Court overruled them. And so that shows something about both how the court is becoming more conservative, but also how when you achieve a change, whether it's through litigation or other political movement, it's no guarantee that you have that permanently. And so one of the important things to remember is the need to continue to enforce it. The other thing that makes litigation more difficult now is there are procedural challenges. Things that seem completely neutral have an impact on bringing social justice litigation. So, for example, the rules being made stricter for declaring a class action undercuts the ability to have cases that will have a broad impact. Likewise, questions that require that, I mean, these seem like really dry procedural issues, but they have an impact. It used to be that to bring a lawsuit, you had to give notice of what the case was about. But that notice was very general. it is now required that it be much more specific. And it's difficult for a person who has no access to the information to include in their complaint something that is specific enough to require or to survive challenges to the lawsuit. And the final thing is the way that there has been a redefinition of both civil rights laws and the Constitution. And so that if you look at the 14th Amendment, which I discussed before, as being designed to provide relief for enslaved people, now the most successful cases have been cases challenging what is claimed to be discriminatory conduct against white people. And many of the civil rights laws are being gutted, either by limiting the ability of agencies to provide protections under the civil rights laws, threatening the elimination of those agencies, or limiting the scope of the laws to require higher levels of proof. So what we could talk about is what could be done. And one thing is the importance of choosing a forum. I mentioned how as litigation strategy, one of the things that you try to do is to pick cases that will be sympathetic and effective. It is increasingly the case that lawyers and communities have to think not of what cases to bring, but what cases not to bring, because of a recognition that bringing the wrong case could result in a detrimental impact for every kind of case. The other thing that could be done is looking to individual state courts or localities, trying to get litigation or legislation that is favorable at the local level, where it might be easier to get that done. And I think one of the most important things, and it's something I've been struggling with a lot earlier, is education and organizing around issues. Shortly before this started, I read a blog by Sherilyn Ifill, who was the former head of the NAACP Legal Defense Fund and a former colleague, who talked about how so much of the discussion now involves the disappearance of race and gender in what happened last month. And instead, the attribution of the election results to purely economic or other non-racial or non-gender topics. And I think that trend, if it is not countered, if we do not continue to point out the existing inequality, in spite of all of the progress that we've made, is one that represents a real long-term threat and something that does disturb me. I promised you a long time ago, in the beginning of my comments, that I would explain why I continue the struggles, both in terms of my own career, but also the struggles that were begun so many years ago by the people upon whose shoulders we all have stood. And for me, it's social justice lawyers like Thurgood Marshall and Charles Hamilton Houston and Constance Baker Motley and so many others. And for you, it can be and should be all of the people who have laid the groundwork for the work that you're doing now. And at least my reason for continuing this work is because I recognize that it's people like this people working with enlightened public advocates and community activists and organizers and legislators continue to fight in the past and continue to fight now against what seem to be insurmountable odds in order to make positive change. Going back to Professor Quigley, he reminds us that every good law or case was dismissed as impossible or impractical for decades before it was enacted. And he reminds us that our work is ultimately driven not by ignoring problems or by returning hate with hate, but by love, which he describes as the love of people who are willing to join together to make a better world. And so, despite all of the real obstacles we face, all of the headwinds that we're currently going into, the creation of that world, of a better world for everyone, is one that is dependent on us and those who will follow us. And just as we are indebted to the people who fought before, we are fighting for the generations that follow. So let's have some questions and discussion.